Good afternoon, dear colleagues, distinguished guests, and all who are following our event online. It's a great pleasure to open this international seminar on copyright exceptions and limitations, an issue which is at the very core of the ongoing review process of the European copyright framework. Copyright exceptions and limitations can be explained quite simple, as the cases when the use of works protected by copyright is permitted without the consent of authors or other right holders, and with or without payment of compensation. Being true, this explanation nevertheless doesn't reveal the whole significance of the copyright matter at the stake. Copyright exceptions and limitations serve or can serve as an effective policy tool, ensuring that there is proper balance reached between interests of all kinds of stakeholders involved in creation and consumption of the content protected by copyright. To reach this balance of interests, or even try to accommodate them in the solution which would provide benefits for all parties involved, is a challenge with which both European and national legislator facing. Further, there is a challenge to find the appropriate balance also between legal certainty on the one hand and flexibility of the legal framework on the other hand. Clear and predictable legal framework is of great importance for the proper functioning of the single market, including digital single market, as well as the flexibility of the legal framework, which is necessary to keep pace with the rapid technological changes and ensure functioning of the digital single market. Although both aspects serve for the similar aims, they are normally in contradiction to each other. In order to ensure more legal security or certainty, the loss of the flexibility must be accepted and other way around. Today and tomorrow we are going to have presentations and discussions on the copyright issues which will reflect tensions I have just mentioned, and also other not least challenging matters of the copyright policy. During the first plenary, which will take place today, there will be a focus on the current legal framework of exceptions and limitations and its impact on the functioning of the single market. Of course, there will be hints how to approach these diverse issues in the nearest future, and the discussion on the possible ways forward will be then at focus of tomorrow's plenary session. Aiming to contribute to the European discussion on the review of copyright framework, Latvian presidency of the Council of the European Union has decided to have more emphasis on the perspective provided by the academia. Our team believes that for the fruitful discussion on the possible changes of the copyright framework, the proper involvement of the representatives of the scientific world is of crucial importance. Thus, today and tomorrow we will have a great opportunity to have exchange of views with some of the leading European legal scientists dealing with copyright matters. The questions to the speakers may and are encouraged to be raised not only by the participants here at the EU House, but also by those who watch this event online. Please feel free to send your questions to the email address copyright@km.gov.lv. You can see the email address also on the screen now. And we will do our best to pass these questions to our speakers, of course, taking into account time limits we have. This event is organized by the Ministry of Culture of Latvia and is very kindly supported by the European Commission. Saying that, I would like to give the floor for opening remarks to Maria Martin-Prat, Head of Copyright Unit of the Directorate General for Communications Networks, Content and Technology of European Commission. So, haven't managed to say this long title. I give the floor to you, Maria, please.
Thank you very much. And if it helps, I still don't manage to say the long title of my new DG. But okay, let me start by obviously thanking and praising the initiative of the Latvian presidency. Is a very timely discussion to be had, and to be had as well with a number of professors and academics that have been discussing these issues for a long time, very often in relation to the work of the Commission. The issue of limitations and exceptions in copyright, it is extremely topical. It's been topical for the last probably 10 years, and there are two issues, I think, that need to be separated there, and they are both equally challenging. One is limitations and exceptions to copyright in a cross-border environment, and the second one is the update of limitations and exceptions to the digital technologies. These are related, but they are different and give different headaches, because generally speaking, all these discussions are quite difficult. You can already see some of the developments that have started to happen. If you think about the Orphan Works Directive, which was the first time, not the first time that we have a mandatory exception at EU level, but the first time that we explicitly indicate its cross-border effect. If you think at international level, the negotiations of the Marrakesh Treaty, which is the very first time as well where we have, and this time is at international level, exceptions which are given a cross-border effect. And we've also had lengthy discussions with methods to facilitate licensing, for instance, on the basis of extended collective licensing or compulsory collective licensing, again, as regards the cross-border effect of such mechanisms. So that is indeed a complex area, a little bit of a terra incognita in legislation, certainly in the legislation of the member states, where this is an aspect that you hardly recognize other than now in the implementation of the Orphan Works Directive and the future implementation of the Marrakesh Treaty. Often you hear, well, part of the problem is because of the optional nature of most exceptions at EU level. But I think, but I'm sure you agree, it's obvious that the issue is a bit more complex than that. It will not suffice to say, okay, here we are, we're going to take Article 5 of the InfoSoc Directive, and in total or in selection of a few of them, we just basically shift this and say, okay, these are exceptions that should be made, that are mandatory, therefore they should be in the laws of the member states, and then we will provide a cross-border effect. The truth of the matter is that if we want to get there, we're going to have to agree a bit more among the member states. You do not make the exceptions function across border if we don't get to a degree of common elements or a level playing field that so far we don't have. And it's not unusual that we don't have. Limitations and exceptions are extremely nation-specific. Every time that I have new colleagues joining the copyright unit, I tell them, once you have memorized Article 5 of the InfoSoc Directive, go and try to find some of these exceptions in national law. Try to find them in German law or in English law. You won't find them. They are extremely difficult, or they are scattered. You will find exceptions for the purposes of teaching or for the purposes of libraries or for reprography, which interweave and are subject to very different conditions and mechanisms that correspond often not only to the legal traditions of the member states, but also the reality on the ground as to the functioning of the beneficiaries, as to the functioning of the collecting societies, etc. So that common playing field, in my view, is going to need probably looking into three difficult areas. One is, can we achieve, and I'm not sure we can, a better understanding of some of the basic concepts that underline some of the exceptions. Think about concepts such as illustration, or quotation, or parody, or disability. I mean, little matters that the Court of Justice tells you every day, oh, these are autonomous concepts of community law, so now they are autonomous concepts of community law. It still, with all due respect to the court, sheds limited light as to what those concepts mean. So that will be part of a discussion maybe. Then, and that's probably the core of the matter, we might need to have a better understanding of what are the conditions for the application of exceptions. When does an exception kick in, and which are the conditions? Because again, for the time being, conditions in member states are very different, and maybe we don't need to conclude very quickly that they need to be completely homogeneous, but we certainly need to have a discussion. I mean, take exceptions like education. You have member states that exclude textbooks. You have member states that made them the exception subject to the non-existence or non-availability of licenses at reasonable conditions. There will be member states that require fair compensation, and then just think about fair compensation. Fair compensation, if you think about fair compensation linked to public lending, in one member state may mean several million euros a year. In another member state, like mine, may mean 100,000 euros a year. Those are things that while you talk about conditions at national level, they may be difficult for the national situation, but that then if you try to look at it, trying to see if you want to give a cross-border effects to those exceptions, things get a bit more complicated. So we will have to look into that. What if we were to think, for instance, as regards the effects of exceptions to the benefit of libraries, if we want to give them cross-border effect, we want the library in country A to be able to give access to its collection in country B, C, and D, which law is going to apply, who is going to determine the conditions of the exception. For instance, if there is a payment of fair compensation, who is going to pay, on which basis? And those are all going to be very, very interesting questions to discuss. And then there is the second aspect. So it's not only the cross-border aspect, then it's the aspect of what is the place and how do we translate certain of the exceptions and limitations that we have to the online environment. And here there is a phrase that is often repeated, but that not because it's often repeated is true, and is technological neutrality. I find it difficult to conclude that because of a principle of technological neutrality, what existed offline needs to be translated equally online. And that goes both ways. It doesn't mean that it only goes to reduce exception. It might also go in order to create exceptions that we didn't think were necessary in the only offline environment. But we need to be careful with such jams. And there are things that give a headache. I mean, I think discussions like, for instance, electronic lending. Is it the same to do public lending in the offline environment and public lending online via streaming to the users' houses? Is a headache. Other things that are a headache, even if properly speaking, maybe you wouldn't say it's an exception, but it's equally difficult, is the exhaustion of distribution right online. So these are questions that I don't think we can conclude there's an automatism, and it's just a matter of clarification of the framework we have, but is something that's going to require more assessment. Now, obviously, the question for policymakers is, at EU level, is what to do at EU level and what not. I don't think anyone believes that all of the exceptions in the InfoSoc directive or in the other directives we have are of equal importance, of equal relevance to the internal market. I mean, as regards some of them, you could even wonder why on earth do we have them there? Well, we have them there because in the end, at the time of the negotiations, there was the objective of having a closed list, but otherwise, certainly there are a few of those exceptions here that we forget that they exist, basically because of their EU effect or even their importance beyond national traditions and borders is questionable. So we will need to determine what needs to be addressed at EU level and at what stages. Is going to be an interesting discussion. And then there is the issue that was just being mentioned by the presidency, is the famous quest for flexibility. And that is like squaring the circle. Flexibility, yes, but you cannot say in the same word flexibility and a better functioning digital single market. I mean, I think in the end, the discussion is going to be as regards at which level we inject flexibility in the system. I find it very difficult to say we need to agree more and get cross-border effect to our framework, but at the same time request flexibility at national level from member states. But that I'm not denying. By that I'm not denying the questions and the problems behind a lack of flexibility in the system. But we might need to see if there is a possibility to inject flexibility at a higher level, and that might include as well being able to adapt our legal framework in a faster, more dynamic manner rather than go through a 20 years period of angst and discussion before we think it's possible to have a discussion to renew the limitations and exceptions in the community framework. That's that. I look forward to the discussions and in particular to good ideas and guidance from those that are going to speak after. Thank you.